Judge. How you doing?
Dr. Brandon, you swear the testimony you should give in the matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Have a seat, please. And if you would, for the record, state your full name.
Sure, my full name is Daniel Kenneth Brown.
And where are you employed, sir?
I'm employed by the Georgia Bureau of Investigation.
Thank you, sir. Please answer counsel's questions. Madam DA.
Thank you. How are you employed with the Georgia Bureau of Investigation?
I'm employed as the regional medical examiner for a 20-county area around Augusta.
Okay, and what does the medical examiner do?
Medical examiner is charged with determining cause and manner of death in cases that fall under the Georgia Death Investigation Act. This would be cases such as homicide, suicide, accident, baby deaths, things like that.
And what type of training have you had to be a medical examiner?
With my background is in medicine, of course. I earned my medical degree at the American University, Coral Gables, Florida. I trained in anatomic, or what they call general pathology, at the University of Tennessee Medical Center in Knoxville, Tennessee. I trained in forensic pathology at the Office of the Chief Medical Examiner for the state of Maryland in Baltimore.
Okay. And what type of training have you had with the GBI since becoming a medical examiner?
As far as training goes, we have in-service training classes where other doctors give 1 hour, 2 hour presentations, and then also I attend 2 conferences a year that are geared toward pathology and forensic pathology in particular.
Have you ever been declared an expert before in forensic pathology in the Augusta Judicial Circuit? Yes. Okay. Your Honor, at this time, the state would seek to admit Dr. Brown's testimony as that of an expert in forensic pathology.
Ms. Dunkar?
No voir dire and no objection, Your Honor.
Thank you. You might so testify.
Thank you. Doctor, did you have the occasion to perform the autopsy on Alana Calahan?
I did.
And initially, if you would explain to the jury what you do with a body once it is received in your office?
In the 20 counties that are within my area, there's at least one coroner for each county, and sometimes there's 1 or 2 deputy coroners. When there's a case, when there's a death that involves the coroner, and it falls under the Death Investigation Act, they call us and ask us if the case needs to be brought to us. In other words, is it something we can do, such as an elderly person who has multiple medical history? We don't necessarily have to do an autopsy on someone like that. But if it's a homicide, suicide, car accident, or a baby death, or an unexplained death, then we'll tell them to bring the body into our facility down on Finnessy Road. At that time, the body arrives in a body bag. After we open the body bag, we take photographs. The photographs are called as-is photographs or arrival photographs. And what that means is, because the bags are sealed at the scene or at the hospital, when they get to us, we break the seal and we open the bag, and then we take a picture of exactly what we see. So that from the time it left the scene to got to us, it should have been in a closed, secure bag, which I've never had a case where it wasn't. After we take those pictures, we clean the body if the body needs to be cleaned, and we take a identification photograph, which is just like any other type of photograph that you'd get on a driver's license or an ID card. After we've done that and we examine the body, we look for any external injury or pathology. So if we see any kind of injury, broken bones or gunshot wounds or stab wounds or blunt force trauma, we will again take pictures of that, and I will document it in my report. Once I'm satisfied that we've taken pictures and looked at the entire external portion of the body, then we do an internal examination. And this is called an evisceration or removal of the internal organs. As we remove the internal organs, again, I look at the internal organs to see if there's any signs of pathology or injury to them. And once I'm satisfied with either that they are within normal limits, or if they need to be photographed or documented further, I do that. If I have to recover any evidence, such as blood, urine, vitreous, which is fluid from the eyeball, I do that. If I need to recover any tissue to look at, say somebody who may have a heart condition, I may want to look at tissue under the microscope, I do that. Once that's done, once we're complete with the internal examination, I'm satisfied, then the body is closed and cleaned and put in a refrigeration unit until the family designates the funeral home or the coroner comes and picks the body back up.
Okay. Your Honor, may I approach the witness?
Yes, ma'am.
Doctor, I'm showing you what's been previously marked as State's Exhibit 205 through 208 inclusive. I just want to know if you recognize these photographs.
Yes, I do.
Okay, and how do you recognize these photographs?
These are several of the photographs that are taken at autopsy of the decedent.
Your Honor, at this time, the state would seek to omit State's Exhibit 205 to 208.
Thank you.
No objection, Your Honor. I believe these were stipulated.
Thank you, ma'am. They're admitted. They're admitted.
Your Honor, may I publish these to the jury?
Yes, ma'am.
Your Honor, we might need some assistance with the lights. So State's Exhibit number 205. What is this photograph?
This is the photograph that we refer to as identification photograph.
And State's Exhibit number 206. What is this a photograph of?
This is a photograph of the exit wound from the projectile that passed through the neck and jaw.
And State's Exhibit 207.
This is the entrance wound on the left posterior surface of the neck at the base of the skull.
And State's Exhibit number 208.
That's just a same photo. I mean, it's the same bullet wound that has a more close-up.
Okay. Thank you. I'm done with this. Doctor, with respect to the gunshot wound, were you able to make a determination which direction the bullet passed through the body?
I can make a determination based on the path of the bullet in the body.
Right.
Yes, I could.
Okay, and what was that path?
It was from back to front, left to right, and it was slightly upward.
Okay. And when you say left to right, are you talking about the decedent's left to right or my looking
The decedent's left to right. When we talk about left or right, we mean in relation to the person we're talking about. So when I said left to right, I meant from her left to her right.
Okay. And was there any deflection, or was it in a straight line?
Pretty straight. It went through two of the cervical vertebrae, which are two of the bones in your spinal column of your neck, the spinal portion of your neck. And but it was pretty much straight line. It didn't deflect off right or left.
Okay. And when you say that it was slightly upward, what are the possibilities as far as her head positioning for that injury to exist?
Okay. The direction, like I said, has to do with the projectile once it enters the body. So when I say upward, that means that it was wherever it entered, it came out or was recovered in an upward from where that was. So, for example, in this case, it was a little bit lower here than it was here. So, again, it depends on the position of the person's head.
Okay. And as far as any, or the actual entrance wound, was there any soot or stippling that you noticed?
No, I didn't see any soot or stippling.
Okay. And were you able to make any determinations based upon that about the distance that the firearm would have had to be before it entered her body?
Well,
I mean, the bullet entered her body.
Sure. Based upon whether we see soot or stippling on the skin, if we don't see it, then it's impossible for us to determine how far away the muzzle of the gun was from the victim.
Okay. What about her, just one second. As far as her respiratory system, was there anything remarkable about the contents or anything that you noted about the respiratory system?
The fact that they were hyperinflated, which means they were overinflated, they were enlarged, and that there was evidence of aspirated blood in the lung.
And what is aspirated blood evidence of?
Aspirated blood is like if you aspirate orange juice. I mean, if it goes into your mouth and you breathe in and it doesn't go into your esophagus and it gets into your lung, that's aspirated. So blood was found in the lungs that had been, while she was breathing, it was breathed into her lungs.
Okay. So she would have still been, after she was shot, she was still breathing?
Yes.
Okay. And what about in her alimentary tract?
about 400 milliliters of blood was mixed in with food particles in her stomach.
So she swallowed blood as well.
So she swallowed blood also, right?
Is there any way to determine how long she would have survived after the gunshot wound before dying?
There's no definitive way. It wouldn't have been hours. It would have been minutes.
Okay. And were you able to determine the cause of death?
The cause of death was a gunshot wound to the neck.
And what are the manners of death?
The manners of death are homicide, suicide, accident, natural, and undetermined.
And what is, if you would explain what those manners are?
Sure. Accident would be somebody that was accidentally electrocuted or accidentally killed in a car accident. Natural death would be somebody that died from a heart attack or cirrhosis of the liver. A suicide is when somebody would take their own life, no matter by what means. Undetermined death, we usually reserve for cases where all the other ancillary studies and the autopsy has revealed negative results. These usually doesn't occur with an adult. We sometimes have that with an infant, or some infants are undetermined deaths because we can't determine whether or not they were a SIDS death or whether they were asphyxiated maybe because they were sleeping with their face in the pillow. So that we call those undetermined. And homicide is just when another person takes another person's life.
And what was the manner of death in this case?
Homicide.
Your Honor, I have no further questions of this witness.
Thank you, Ms. Dunkar.
Thank you, Your Honor. So, Dr. Brown, you were unable to determine how close the defendant was to the victim. Is that correct?
That's correct.
And also, we don't know the angle of the bullet through the body because the head could have been.
I know the angle through the body, but I don't know the angle where the head was turned.
Okay. No further questions, Your Honor.
Thank you. Anything else?
No, Your Honor.
Thank you. Dr. Brown, thank you, sir.
Yes, sir.
Ms. Payne, you might call your next witness.
If I could just have 1 second, Judge.
Yes, ma'am.
Your Honor, at this time, the state would rest.
Thank you. All righty.
Your Honor, the only other thing that I would just add for the record was that we had previously stipulated to States Exhibits 6 and 7. I don't believe we ever formally entered them into evidence on the record, but we did publish them to the jury.
And 6 and 7 were published to the jury. That's correct.
Yes.
And they are admitted pursuant to the stipulation. Yes. All right. Well, ladies and gentlemen, is that Ms. Dunkar, is that correct? That was stipulation?
Yes, sir.
Thank you. Ladies and gentlemen, the state has now rested this case, and so that will be all the evidence you'll hear to this point from the state. There are a couple matters that the court has to take up before we can go on with the case, and so I'm going to ask y'all to step out to the jury room, and it shouldn't be too long, and then we'll bring you back out. Thank you. All rise for the jury. All rise for the jury, please. All right. The record will reflect that the jury has retired to the jury room temporarily. Now, Ms. Dunkar, the state is rested. Do you have any motions or anything that you desire to make?
Yes, Your Honor. We would just make a motion for a directed verdict, arguing that there was not sufficient evidence that a reasonable jury could find Mr. Schmidt guilty of malice murder, felony murder, and felony murder.
Thank you, ma'am. Madam DA, you want to just submit?
Your Honor, I'd submit.
Thank you. As you know, the court keeps a checklist and of each element of the offenses, and so I check these things off as they're covered and know which witnesses supplied the information. And when I have enough, I just quit keeping the list, and I quit keeping this list of a little while back. Viewing the evidence in the light most favorable to the prosecution, a rational trier of fact could find the essential elements of each of these crimes beyond a reasonable doubt. So the motion for directed verdicts is denied. All righty. Do we need to take up the matter of your client testifying?
Could I have a moment to speak with my client briefly before?
Yes, ma'am. Yes, ma'am, you might. Y'all want to do it here? Y'all want to step back and?
We step back there.
Yes, ma'am. Ms. Duncar, I'll let the record reflect that y'all are back.
Yes, sir.
It doesn't reflect that you ever left, for that matter. But the question I have is, y'all have had several minutes to confer. Do you need additional time?
No, sir.
And is your client ready to engage in the colloquy with the court regarding his testifying?
Yes, sir.
Thank you. Would you stand, please, sir? Thank you. Mr. Schmidt, I need to ask you some questions to make certain that on the record that you understand all of your rights with regard to your right to testify and also your right not to testify, because you have that right as well. Do you understand?
Yes.
Okay. Do you understand, sir, that you have the right to testify in this case, and if you want to testify, there's nobody who can prevent you from doing so? Do you understand that?
Yes, sir.
Do you also understand that no one can make you testify? No one can compel you to testify. That is, just like you have the right to testify, you also have the right to not testify if you don't want to. Do you understand that?
Yes, sir.
Thank you. Do you understand that not your lawyer, but you personally are the one that has to make the decision as to whether or not you will testify?
Yes.
You understand that?
Yes, sir.
Do you understand that if you do not testify, then upon a proper instruction from your attorney, then the jury will be instructed that your decision to not testify cannot be used against you or held against you? Do you understand that?
Yes.
Do you also understand that if you choose to testify, you will be examined by your attorney and then cross-examined by the assistant district attorney? Do you understand that?
Yes, sir.
Yes, sir. Understanding each of those matters that we just discussed, do you desire to testify or to not testify in this case?
I decided not to testify, sir.
You desire to not testify.
Yes.
Thank you, sir. The court finds that the defendant has made this decision to not testify with the complete understanding of his rights in that regard. And you might be seated. Thank you, sir. Ms. Dunkard, do you have additional witnesses that you desire to call?
No, sir. The defense will rest.
Yes, ma'am. I'm going to allow you to do that. I will bring the jury back in, and then I will ask the jury if, and then we'll ask you to call your first witness, and you might then rest.
Yes, sir.
Thank you. All righty. With that, anything further to take up before we bring the jury back in?
Are we going to dismiss them after that, or what is your plan?
My plan actually is to proceed into the charge conference, but I'll cut the jury loose and send them home. We're shooting pursuant to our earlier conversation, 8:30 in the morning.
Yes, sir. That's fine.
That works for you, Ms. Dunkard?
Yes, sir.
Okay. All right. That's what we'll do. Anything else we need to take up before we bring the jury back?
I can think of, Your Honor.
All right. Thank you. Let's bring the jury back in, please. All right. Everybody can be seated. Thank you. Ladies and gentlemen, the jury, the state has rested. Ms. Dunkard, you might call your first witness.
Your Honor, the defense rests.
Thank you, ma'am. Well, ladies and gentlemen, the jury, that means that you've heard all the evidence that you're going to hear in this case. The matters that remain are the closing arguments by counsel and the charge by the court of the law. These matters will probably take 2 hours, 2.5 hours. It makes no sense to do this late in the afternoon to get started on this. And we also have another procedural matter that we have to take up that's going to take probably about an hour. And so rather than get y'all started late and not having much time to deliberate today, I would much prefer to start tomorrow morning about 8:30. Does that work for y'all? All righty. I want to caution y'all, no, not caution you, but just come advise you that the court always assumes that whatever we do, we have a great deal of business, and whatever we do will be finished by Wednesday afternoon. It didn't work out that way this week, and that's perfectly fine. It's not a problem. But if there seems to be a lot of commotion, a lot of people, more people than even today that you see, it's going to be because other things are scheduled. We've tried to reschedule things for later in the day tomorrow because we can do things while y'all deliberate. We'll continue to conduct court and handle other matters. But in the meanwhile, in the morning when you show up, if it looks like a little chaotic, and hopefully everybody got the word that they're not to be here early in the morning. But if they are, then y'all just understand that that's just the nature of the beast. Don't worry about it. Y'all have priority over everybody. Okay? Having said that, I need to point out a couple other little things. You now know everything about this case that you're going to know. I want to be very clear clear on this, that you are not to go home and make any attempt to educate yourself anymore. If there are questions that you have unanswered, if there are issues that you're not satisfied about at this point and that you haven't begun your deliberations yet, you'll need to address those during your deliberations. And that's the process of deliberation. That's what it's all about. It's important, very important, and I say that because it's very important that you not make any effort to try to educate yourself any more about this case, because the law is and the rules are and the fairness is and our justice system works because you will make your decision in this case based solely on the evidence and the test that's been presented in this case. And you recall I've said this numerous times, that that's the testimony that came from those who took the oath on the witness stand and from the exhibits that have been admitted into evidence in this case. And so that is the information that you will base your verdict on tomorrow. And so I want everybody just to be crystal clear that you are not to watch the news, you're not to go online, you're not to attempt to find out anything else about this case than you know right now. And so you just have to have faith and trust the system that it will work out. And so everybody clear on that? Anybody have any questions about that? And again, as I've mentioned several times, the very nature of a discussion of a case causes you to begin deliberations. Now, there's no way I can say don't think about the case because, obviously everybody is, you can't control that issue. But it would be wrong to discuss the case with anyone, and probably more harmful now than it would ever been, because now you have all the information you're going to have. And so when you begin discussing the case, you need to do it as a panel of 12 after you've received the jury charge from the court, and we'll take that up, and you'll be doing that in the morning. Anybody got any questions? Y'all's instructions for the rest of the day is just enjoy the rest of the day. And y'all have a good night's sleep. We'll be here again 8:30 in the morning. Everybody clear on the time, 8:30. And so hopefully we'll get started promptly at 8:30, and we'll get rolling. All right, thank you. Y'all have a great night. All rise for the jury, please. Any motions, issues, matters that need to be taken up before we begin the charge conference? And Will, I think I'm going to need your help with something. Well, I can actually do it from here. You have the copies of the requested charge from the...
And the original, sir.
Yes, ma'am. I'll look at those, please. Thank you very much. I'm just going to take these two and get them back from you when you finish. Thank you. Well, I'm going to use these. My copies of the requested charge that we've printed off or downstairs. Counsel, y'all prepared to go forward with the charge conference?
Yes, Your Honor.
Yes, sir.
Okay. Before lunch, I suggested to y'all that there's some issues that I was hope that y'all would think about over lunch, and I didn't do that with any intention of disturbing your lunch. But that might have been part of the results of the conversation. Do y'all want to go through the requested charge, charge by charge? Does that suit everybody? And Will, if you could, it would probably expedite things just slightly if you would run downstairs and see if you can round up off my desk the requested charge. And I think, did you not print yours on yellow paper? There would be, and that's what you can look for. That's helpful, by the way. It's been very helpful tracking this exhibit list throughout this trial, it being on green paper. Maybe we can do that in the future, so it's a matter of course. Thank you. Let's begin with the defendant's requested charge. And we'll begin with requested charge number 1. And that's basically, most of these are most of these, the requested charge, and in fact, the significant number of the charges from each of you are merely pattern charges that the court will give and gives in every case. And so let's begin with the defense request charge number 1 is issue and plea of not guilty. The court, of course, intends to give that using the pattern charge. If I say I'm going to give that, let me make sure that everybody understands that when I say I'm going to give that, doesn't mean I'm going to use exactly the language that you've got. I will use the most current approved language that the judges have in our charge book. And by the way, when I say I'm going to give that, I'm inviting you to say, Judge, I object to that charge. That doesn't mean I'm going to give it without any hearing from you. Okay? We're clear on that? All righty. Number 2, presumption of innocence, burden of proof, reasonable doubt. The request is the pattern charge, and the court will give that. Number 3 is the jury, judges of law and facts. The court will give that. Number 4 is evidence generally, and the court will give that. Number 5 is the charge on direct and circumstantial evidence, and that's also the pattern charge. The court will give that. Number 6 is grave suspicion or bare suspicion. That's the pattern charge, and the court will give that.
That charge on the basis that there is more than bare suspicion, and it could be interpreted as a comment on the evidence.
Yes, ma'am. Thank you. The court overrules that objection and will give the bare suspicion request. Madam DA, if you would, please make a note so that you might timely object to that charge after it's given tomorrow, if you don't mind. Thank you. These issues all need to be preserved so they can be, if the opportunity comes to address those, our courts can do that. Number 7 deals with the credibility of witnesses. And of course, that's the pattern charge as well, and the court will give that. Conflicts in testimony, 131:20. We have a defendant who has not testified. I'm concerned about Noggle, and which deals.
We can withdraw our charge number 8.
Y'all withdraw that one. And I would note that the state also requested that. I did not have any numbers to attach to the state when I prepared this, the draft I'm working from. The state also would withdraw its requested charge as to conflicts in testimony.
That's fine with me.
Thank you. Number 9, the witness impeachment. We're going to give witness impeachment, but we only want to give witness impeachment as to the extent that, thank you, ma'am. Thank you, sir, I'm sorry. As to the extent that it is actually applicable under the facts in this case. And so A and E were the ones that I thought applied. Or you have A and D. I think that there's actually an E now, but that's fine. Same ones, prior contradictory statements and disproving the facts to which the witness testified. Do you agree with that, Ms. Dunbar?
Yes, Your Honor.
Thank you. As to defendants number 10, witness impeachment, that's the pattern charge, and the court would intend to give that. Number 11, the prior consistent statements. Our appellate courts have found on that as being a comment on the evidence that somehow elevates, and I think I agree with them. It somehow puts a focus and or emphasis on on prior consistent statements and prior inconsistent statements, they haven't addressed that, but the analysis is the same. And so the court would under those circumstances, decline to give prior consistent statements as substantive evidence. The idea being that it's also adequately covered under the general charge as evidence is evidence. And thank you. So no objection to the court not giving that, Ms. Dunkar?
No, sir.
Thank you. And the next request, charge number 12, is the prior inconsistent statements. I would decline that as well. Now, they're still going to get less on and a charge on inconsistent statements as part of the impeachment charge. So it will still be dealt with or addressed there. And I gather no objection from that. Thank you. And again, to the extent you do have objections, Ms. Dunkar, please make a note to yourself to renew those objections tomorrow. The court will give 13, which addresses the defendant's failure to testify, and the court will give that charge. Number 14 deals with there being no presumption of criminal intent, and that being part of the pattern charges and an accurate statement of law. The court will give that. And number 15. Number 15 is the lesser offense. The intention of the court is when we get to the next charge, which is 16, the voluntary manslaughter definition and the last of the charges requested by the defendant, 15 will turn on whether or not 16 is given. If 16 is given, the court would give 15. If 16 is not given, of course, we would not give 15. All righty. Which brings us to the big issue of the day, and that is the voluntary manslaughter. And Ms. Dunkar, I will hear from you.
Thank you, Your Honor.
And I'll just tell you what the court's intention or sense is about it. That at this point, the court's of the opinion that there's not been evidence, but that would authorize the court giving that charge, and I will hear from you though about that.
Thank you, Your Honor. Starting out that, and I don't mean to, I have trouble if I'm arguing the case at this point. I think that there's a little bit, I was trying to separate out just stating what the evidence was and arguing the case, but I think in this case it's very important because there has not been established what happened in that room. So we're all looking at the facts that led up to this incident. I think we all can, a number of the cases that were provided by Ms. Payne had defendants who, number one, testified at the trial that, there was no provocation, or they were arguing self-defense in the alternative voluntary manslaughter. And in this case, looking at all of Aaron's statements, there's no doubt that all of them, to the police were lies. And it's difficult to look at his statement and on one account looking at it as lies tending to prove malice when it could just as easily tend to prove fear. We have the evidence that he wasn't. There was nothing that seemed to be bothering him leading up to this, that he followed the house rules leading into this incident. He took off his shoes. He untied his shoes. He knew Amanda was coming back to the house in short order. All of these things that suggest that something happened. We don't know what happened, but that something happened that was either... it seems to suggest that something happened that was a sudden outburst. These normal, ordinary behaviors that he had leading up to this event. We've, provided evidence as to why the gun was being carried that wasn't a premeditation, and I think that there's been very little, if any, evidence shown to argue that there was any premeditation. And at this point, it's just as likely that it is that something suddenly happened there as it is that it was a premeditated, cold-blooded murder. And obviously, as you know, this is not an affirmative defense. And in the pattern charges of the lesser included and of the voluntary manslaughter, it explicitly says that it is the state's burden to overcome a voluntary manslaughter in order to prove the guilt of malice murder. And I think at this point, while it is not affirmative evidence of a provocation, we certainly have evidence that shows he was not in a state going to kill someone before he got in there. And I think from that, it's slight evidence that you can infer that something happened. And because that, I think it would be necessary to charge the jury as to voluntary manslaughter.
Ms. Dunkhorst, your argument in essence is that the evidence that you point to, not trying to be sarcastic or anything, is in fact the lack of evidence. The fact that there's that.
Well, it's the lack of premeditation. Yes, it is. It's the lack of premeditation and that things were normal leading up to this. But there is also the evidence of all of the state's witnesses that he had this temper outbursts. And that is, evidence that suggests that is a possibility of what happened. I think that there certainly is. It is essentially evidence in the negative, yes. And that's not something that's been really addressed in any of those cases that we have, neither mine nor Ms. Payne. So we are in a unique territory here. But I think that is certainly his past coupled with his behavior leading up to and after the event is the slight evidence necessary to charge the jury on voluntary manslaughter. I don't think it's running the risk of putting it in there solely for a jury nullification process, because I think at this point it's, the evidence, it's just as likely one or the other.
Thank you, ma'am. Madam DA? I presented the issue to you not only do you have to respond to Ms. Dunkar's argument, but also with the spin on it that the Supreme Court has held that it's never error to give voluntary manslaughter. It's reversible error to fail to give it when it is a sole defense and when it's with the caveat that it also has to be authorized under the evidence. And without commenting on Ms. Dunkar's argument at this moment, I will submit to you that the court would, if you have no objection to the charge, the court would will see that as being there be no objection to the charge and will give the charge. If you object to it, the court will hear whatever arguments you want to have and they'll make a decision on it.
Your Honor,
you understand the risk and the downside.
Yes, sir.
And if in the world of the appellate courts, where they, with all due respect, but they have literally months and months to ruminate over cases and issues and matters and what how the decision will impact future law and future cases and future holdings, that they may find something that this court has not found. And so I will, having said that, I'll turn it over to you.
Thank you, Judge. Your Honor, the state would object to that charge being given on the basis that there is absolutely no evidence, not even slight evidence, that this was anything other than either murder or, if you look at some of the evidence, there is suggestion that it was an accident. And I do believe that the court is under some obligation to charge on that just because of the fact that the evidence does show that. But the case law that I provided, Your Honor, I've also provided that copy of that case law to Ms. Donkar as well. Specifically, if you look at Davidson versus the State, which is a 2011 Georgia Supreme Court case, which holds that basically in this particular case that a charge on voluntary manslaughter was not available to a defendant whose own statement unequivocally shows that he was not angered or impassioned when a killing occurred, and when the other evidence does not show otherwise. The only evidence in this case presented by the state with regards to, specifically what happened was the defendant's statement, and his statement maintains that this was an accident. There is no suggestion. In fact, there's evidence absolutely to the contrary from the defendant's own mouth that Alana was a good person, that he was her friend, that she considered him her friend as well, and that there was no tension, there was no argument. The timeline, the state's been specific questions, making sure to nail down this timeline. The timeline suggested there wasn't even enough time for a conversation to take place, ill-willed or otherwise. Certainly, the principles of justice would not agree that a defendant should be afforded a defense which has not been shown in the evidence at all. And in this particular case, voluntary manslaughter would require that the evidence, reveal some sort of inclination that there was serious provocation on the part of the victim to somehow provoke this defendant into killing her and support that charge. We aren't charging him on breaking or entering an auto or shoplifting, because there's no evidence to that degree. Just like there is no evidence whatsoever that this was a voluntary manslaughter. You cannot infer from what is not there some conjured up defense. And if that was the case, we would also have to charge on insanity or self-defense or all of these other things that are not being requested of Your Honor. So I realize that is a relatively large gamble in the eyes of the court, but Your Honor, that is a gamble that I'm willing to take on this case, simply for the fact that the evidence is not so mitigated to warrant a charge on voluntary manslaughter.
Thank you. I would just remind everybody, so there's no buck passing here, because what I did was I gave the DA an opportunity to allow the charge, to withdraw her objection to the charge. It's still a function of the court's function to determine whether, as a matter of law, it's not up to the DA, whether as a matter of law there is no evidence, even slight evidence, to support the charge. And as I noted earlier, before lunch, that I spent the entire evening last night, yesterday after court, last night at home, this morning very early at home, because I awakened early and went with a notepad and a pen, picked it up immediately and started just working through the issue. And it's a relatively simple issue. It's just complex because it is the sole defense. And and I would just point out, Ms. Dunkar, you've not been able to present to me. You presented to me in the negative, which we may have a chance to argue on appeal, establish some law in that regard. But there's nothing that you were able to point to that would even suggest that there was even slight evidence, other than the absence of us knowing what actually happened there, which is true. We don't know. You can infer from the evidence, the other evidence, the physical evidence, what might have happened, and so the court will decline to give the defense requested charge 14, and will decline to give defendant's requested charge 15. The court will give, however, because I think it is, if nothing more than suggested in the defendant's statement, will give the charge on accident. I think that it may also address this issue. That's not the charge that you travel, the defense you traveled under. But I think that it is, that there's, if nothing else from the statement, there's some evidence that possibly there could have been accident, and the court will give that charge. All right, not at the request of the DA. That's the court's. The court's going to do that on its own. And I would just suggest to you that the law is clear also that it's error for the court to fail to charge if there is a sole defense, although maybe not asserted or urged by counsel, and but it has been raised by the evidence that it would be reversible error for the court to fail to charge on that sua sponte, and so the court will be charging on accident. Now, let's take a look at the state's request to charge. And this will start off a little slower than it ends up, because it'll end up with all your pattern charges are at the tail end of this one. The malice murder charge, the court would intend to give, using the pattern charges, request charge number 1 on malice murder. And I'm going to, as we do this, and we'll use the pattern charge. And we'll also use the as to premeditation, length of premeditation on malice murder number 2. That the court will incorporate that request to charge into this malice murder charge. The Georgia law does not require premeditation, and no particular length of time is required. As to count number 3, motive, the court will give state's request to charge number 3 on motive. That's also a pattern charge. Proof of a motive is not essential to constitute the crime of murder. As to felony murder, the court will give number 4. We'll give number 4 in this fashion that and I'll just read this to you very briefly. A person also commits the crime of murder when in the commission of a felony, that person causes the death of another human being with or without malice. I further charge you that under the laws of Georgia, aggravated assault is a felony offense and is defined as follows. Y'all follow me on this, because I'm going to intend to give the definition, since there's no separate charge in the indictment for aggravated assault. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon. To constitute such an assault, actual injury to the alleged victim need not be shown. It's only necessary that evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim. The state must also prove as a material element of aggravated assault, as alleged in this case, that the assault was made with a deadly weapon. A firearm, when used as such, is a deadly weapon as a matter of law. I intend to charge also, and I'll go ahead and cover this now because we'll get to it in a second. I charge you that the offense of felony murder does not require malice or the intent to kill. It does, however, require that the defendant possess the requisite criminal intent to commit the underlying felony. Now, and this is where we get into the issue I mentioned before. We have to tailor the charge to the facts of the case. This is a pretty straightforward felony murder case. And a lot of the, several of the requests to charge deal with the charge that the court would give, as we did in that Burke County case where the underlying felony was not a violent felony, not a dangerous felony. And so I don't know that we need to. We've already told the jury in the felony murder to find that aggravated assault is a felony offense, and so I'm not going to give States 5, which just says that a felony means any felony is dangerous per se, or which is what we have in this case. That's aggravated assault, which by the intended circumstances creates a foreseeable risk of death. All right, you withdraw 5. Thank you. Number 6, no intent to kill, and I think that's covered in what we just described. So we withdraw 6.
Yes, Your Honor. As long as it's included as you just previously.
Yes, ma'am. Number 7, I charge you that the difference between felony murder and malice murder is that felony murder involves a non-intentional killing committed in the commission of a felony. The only difference is the absence of intent and malice in the latter. And I would suggest to you that that may have been what the Burke v. State said, but that's an improper statement or incorrect statement of the law, because it implies that no intent is necessary, and there's still intent to commit the underlying felony. So okay, thank you. All right, thank you. So 8's withdrawn. And 9, I think, is covered in here, also covered in the proposed charge that I've already read to you. That includes the definition of aggravated assault, and when they assault someone with a deadly weapon. And so you withdraw 9 to the extent that it's already included?
Yes.
Thank you. Now, the simple assault statute, the second part of that was, it has been my position that
I think we can withdraw that one.
okay, thank you.
And number 11, I think, is already encompassed in the remainder of the, or in the pattern, or in the charge that the court previously mentioned that it was your intent to give earlier. So to the extent that
You're
this
looking at 11 now?
Yeah.
All right. I'm making notes as we go through, so it takes me a second. Yes, ma'am, that's fine. We've got that covered. So you're withdrawing 11?
Yes, sir.
Thank you. 12 is where we get into the less than something that's a non-dangerous.
Yeah, that's fine. We can take that. I think that's already covered.
Okay.
And 13 is already covered in your original charge as well.
Thank you. Number 14 is the definition of possession of a firearm during the commission of a crime, and the court does intend to give that. The court intends to give death by taking, but we have to tailor that to the indictment also, and that there and in the verdict form. My intention is the statutory definition will be a person commits death by taking when that person. Let me make sure I've got it here. Hold on a second.
I guess it's A.
That is just A. When that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken or appropriated. So I would just give A only on that one. That's satisfactory with you,
Yes, sir.
MDA?
Yes, sir.
Okay, thank you. And the court will give number 16, the juror empathy and prejudice.
And the defense would just like to note an objection to number 16. They're already instructed to only look at the evidence.
To do what now?
The jury is already instructed to only look at the evidence.
Thank you. The intention of the court is to give the charge on juror sympathy and prejudice. I think in a case that involves, as in this case, circumstances that a lot of the evidence that came in this case, or a lot of the testimony, was really not relevant to the issue of whether or not this defendant had committed the offense that is alleged to have committed. It came in unobjected to. The court was concerned enough that I was even scoped out the issue of at what point should the court sua sponte get involved in that issue. It's always been my practice since I've been on the bench to let the lawyers try their cases without the court, other than just you stay within the confines of the law. That I don't get involved in those issues, and so I decided that wasn't my issue. Now, if it had been hearsay or something like that, it would have been different. But as to that relevancy, we can overlook that. And so I think in this case, especially given the fact that there's a lot of irrelevant information has come in and been allowed to come in, that I think the charge is warranted in this case in particular. And I will ask, Will, if you would make sure that we take a point. I got two Wills looking at me. If we take a look at let's make sure that Dugan v. State is still good law and that there's not been any comments on the appellate level regarding that holding. Can you make a note of that? Thank you. Number 17, the presumption of innocent, burden of proof and reasonable doubt. Of course, the court's going to give that. That's a pattern charge. Read back to the pattern charges. That the no presumption of criminal intent, 18, the court will give that, as will the court give the direct and circumstantial evidence, which is 19. Conflicts in testimony is 20. Let me go back to 20.
And I think 21 is the same thing. I apologize.
Thank you. I just want to make sure that I had it off my list, and I know we did that with the defendant because she requested the same, or he requested the same charge. But so 20 is withdrawn. Thank you. And what'd you say about? And 21 is a good charge, but the court will use the current pattern charge as the 21. 22, witness impeachment is, do we have anybody that was convicted of a felony that testified? If we did,
No.
it was never brought out.
Although,
I don't know whether somebody might have had some criminal history or not, but I don't have any evidence of that. So I would decline to give. I'm going to give the general impeachment charge, but I'm not going to give 22. We will give 23, including the portion that deals with the statement provided by a juvenile. We'll give 24 that deals with voluntariness and detention, 25 which deals with the burden of proof as to rights, 26 which deals with the condition precedent to the consideration of the statement. As to 27, for the same reasons that we haven't talked about, they didn't occur in this case. The accused is not testified, so y'all we would withdraw that?
I think that's,
okay.
I apologize. I
was going to make the point that I wouldn't have given that had he testified, because I'm not going to single him out. I won't single out other witnesses. I'm not going to single the defendant out. And then, and I will give the one talking about singling out witnesses. We had several witnesses that did testify as experts, and I will. 28 is informative in that it provides that they can give opinions, which other witnesses are more restricted in what they can give. So 28 will be, we'll give 28. Anything further that we need? Any objections to the, I know other than the ones that have already been noted, any general objections to the proposed charge? Any other issues that we need to take up before we reconvene in the morning at 8:30 to argue the case?
Nothing on behalf of the state, Your Honor. I just would ask, are we going to receive a written copy of the charge that the court?
We'll probably have this thing ready for you in an hour. I would hope. If y'all are going to be around in an hour, you want us to just email it to you.
If you could, I'm going to be back at our office downtown, so if you could email it to me, that would be
great. Yes, and we'll be glad to email it to you. Well, you've got the email addresses for everybody. I think I do too. And all right, Ms. Payne, you want an email to you too?
Yes, sir. That'd be easy.
That'd be fine. We'll email you proposed. And let me just ask that you do this as you read these over. If you note any typographical errors or any omissions, anything that you think there's a problem, please feel free to get back with the court, and we'll be here in the morning. Let's try to be here about 5 minutes early, just so if there's an issue that we need to take up that's a housekeeping matter, typo, something like that, something that I said I'm going to put in there, but I just didn't do it. We can deal with that, and we can deal with that and not delay the closing arguments. All right. Anything else?
Yes, sir.
We're in recess until 8:25 in the morning. All right. That's it. Thank you. All right. go back on the record. Let the record reflect that the defendant is present, as is his counsel. The DA is present. We have the jury's present, not in the courtroom, but they're ready in the jury assembly room to come in. Let the record also reflect that the evidence closed yesterday afternoon. We took up our charge conference, had a charge conference, and the court entered a number of rulings with regard to the charges that will be given in the charge today. Overnight, and I asked counsel, we emailed counsel a copy of the charge, with written charge that'll go out with the jury. And I had invited counsel, if there's, to advise the court if there are any mistakes or errors that they see in that please let me know, so we can have as close to a perfect form as we can hope to achieve when we send it out. But during the night, the court received, and I don't know what time it came in last night. It was late. It was 9 o'clock when I opened my email, just check it one more time, and there was an email from defense counsel adding a new request to charge that was clearly not timely made, requesting a charge on the lesser included offense, or arguing that as a lesser included offense, or seeking a charge on the lesser included offense of involuntary manslaughter. And that's where we are right this second, when that is pending. And so let me hear from counsel. Ms. Dunkar, you're the one requesting the out-of-time charge. Go
yes,
ahead.
Your Honor. And it was out of time because obviously over our objection.
I'm going to interrupt you 1 second just to also add to that little comment I just made, that the court also announced yesterday that it would be given the charge as the jury, it would be authorized by the evidence as the court felt given the charge of accident. I think the DA even suggested that she concurred that was even present in and that charge is appropriate under the evidence. But now you're seeking a charge on that would for involuntary manslaughter.
Yes, sir. And the reason it is untimely is obviously over our objection. The court has chosen not to give the voluntary manslaughter charge, having ruled that there was not even slight evidence of the voluntary manslaughter, even acknowledging that was our sole defense. So we felt the need to at least present a charge for involuntary manslaughter, lest it be essentially ineffective. The case law that I was provided today, some of them apply, some of them don't seem to.
I don't have the case law that you provided.
I didn't know that I was provided.
That you were provided.
That I was reading through. Obviously, there is testimony that Aaron was messing around with the gun in the house when it was loaded. That in and of itself could be reckless conduct, and thus I do think that it would be appropriate to charge the jury with involuntary manslaughter. I think there's plenty of evidence that would be an appropriate charge. In the alternative, I think that it's not error to charge them on that when there is this evidence that it could be involuntary manslaughter.
Do you acknowledge that under the law, just throws out that the court would not, I'd be concerned about whether or not it would be appropriate and authorized to give a charge on accident and involuntary manslaughter if the court were to do that. I'm not saying the court's going to do that.
I think that they're not mutually exclusive. I think that certainly they can find either that it was in pure accident or that he was acting recklessly. I think that they're not at all mutually exclusive. I think that certainly it will take a different finding of, they are mutually exclusive, that it's not error to give both those charges because there are two very different circumstances that the jury can find. One being that Mr. Schmidt acted recklessly and without regard to Ms. Calahan's life, and then also that it was just a pure accident. I think those are two very different charges that are both necessary.
Thank you, Madam DA.
Your Honor, one of the cases that I provided counsel in, Your Honor, is the Lashley case, which is 283 Georgia 465 of 2008 Georgia Supreme Court case. And in that case, which I found to be specifically on point, the court held that with regard to whether, well, in that case, the appellant he accompanied his requested charge on involuntary manslaughter with a request to instruct on reckless conduct. With regard to whether that misdemeanor was a lesser included offense of aggravated assault, the indictment alleged that the appellant committed the greater predicate offense by shooting the victim with a gun, which is exactly what we have in the case that we are dealing with today. There is no evidence that although appellant intentionally fired the weapon, he did not intend to shoot Ms. Jordan and acted only with a conscious disregard of the risk that doing so would endanger her safety. In this case specifically, they held that the evidence established either that the appellant intentionally shot and killed the victim, or that the pistol discharged accidentally and no offense occurred. Whereas here, the evidence shows either the commission of the completed offense of felony murder and aggravated assault, or the commission of no offense, the trial court is not required to charge the jury on a lesser included offense. And in that case, Your Honor, the court held that the trial court did not err in failing to charge on involuntary manslaughter, specifically where accident was given, which is exactly what we have in this case. And Your Honor, I still believe that the evidence in this case, either it was accidentally fired, and I mean the defendant never once mentioned that the gun could have fired because his finger was basically on the trigger. Instead, he acknowledges that perhaps the hammer went up and caused the bullet to discharge from the firearm, but he dances all around the fact that he ever intentionally fired that weapon, and it either is an accident or it's murder. There's nothing in between. That case is specifically in point.
Let's have a little discussion for just a minute. We don't have a lot of time, but this is a critically important issue. Every one of the cases that you submitted, though, can be distinguished on the basis of factually distinguished in that, for one reason or another, I won't go into others because you haven't discussed those just now, but you did discuss Lashley. And Lashley, and let me just make this observation that part of the evidence that the state introduced is the statement of the defendant. And the statement of the defendant, of course, was this rambly statement. Now, I'm not talking in terms of the weight to give the evidence. I'm not talking in terms of the believability of the evidence. I'm just talking about the fact that there is evidence out there that because it's out there, the jury be authorized to believe it or not, or disbelieve it. It's up to them. But in this case, the Lashley case, well, let's take a look at that. Was there evidence that he intentionally fired the weapon?
In this case?
In Lashley?
He says that if you look at on page 2, that first paragraph at the bottom of the first paragraph, at trial, however, appellant testified that he did not intend to shoot or threaten the gun, that the gun was a raggedy gun and simply discharged. The weapon belonged to Ms. Jordan, and he testified that he had removed it from his pocket because she asked him to return it to her.
The court's going to rule on that, on your request. And I'm going to deny the request. I'm going to deny it on the fact, one, it's not timely. I'm going to deny it on the basis that the court has indicated yesterday, without objection from anybody, that it would charge on accident. That the portion of the statement where he had no intention of even pointing was that he didn't intend. He realized he was pointing the gun at her. He was just trying to get the bullet out of there, trying to get the gun unloaded and then discharged. I cannot see where that part of the statement, there's never any part of the statement that says he was intentionally pointing the gun at her head or anything of that nature. I think that the evidence would authorize an acquittal for the finding of accident, or it would indicate that this young man intentionally took the life of that child. So I'm going to deny the request. We'll go with the charge as we provided to you by email last night. And Karen, have you got copies for everybody? Does everybody have a copy already? If you do not have a copy, I've had Karen prepare copies, and I think she's brought those up with her. All right, so that's the ruling of the court on the motion for a charge on involuntary manslaughter. I'm going to deny that motion for the reasons that I just stated. All right. Now, y'all ready? Do you need, Ms. Doncor, do you need a moment?
Nope, I'm fine.
Thank you. Let's bring the jury in, please.